The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court now sitting.
Thank you. Please be seated. Now call the second case on this morning's docket. It's case number 103505 and 103506 in the matter of the care and treatment of Douglas Girard. I believe there's also another individual involved.
That's correct, Your Honor. It's Eugene Mallard.
Mr. Mallard.
Yes,
all right.
Yes, Your Honor.
And I hope neither counsel this morning take it personally that you lost some of your audience.
Well, I didn't think they were here to see me to begin with, so that's fine. Thank you. May it please the court, my name is Sam Kepfield of Hutchinson. I represent the appellants in this case, Douglas Girard and Eugene Mallard. I would like to reserve 3 minutes of rebuttal time.
3 minutes is granted.
Thank you, Judge. May it please the court. This case is not quite as complex as the one we just heard. This is a sexual predator commitment, two sexual predator commitment appeals. It's on petition for review after the Court of Appeals upheld the trial court's decision to judge admissibility of actuarial evidence based on the Frye standard and not the Daubert standard. The issue then is fairly simple. Should Frye or Daubert govern the admission of the evidence of the Static 99 and Minnesota Sex Offender Screening Tool, or MinSOST, tests in sexual predator commitment proceedings? The Court of Appeals, as you know, held that the law on admissibility standards for admitting expert testimony in Kansas is well established and not affected by my arguments. The arguments concerning the accuracy of those tests goes to the weight of the evidence rather than the admissibility. The trial court in these two cases were filed in the same county, same counsel, same issues basically, and the hearings were held 9 days apart. The first case, I believe Mr. Mallard's case, the court held that Frye governed, but in the second case, Mr. Girard's, the court did something different and said, well, they could be admitted even independently of Frye, but even if we don't agree with that, it is admissible under Frye. The Court of Appeals appears to have retained the Frye standard as far as I can tell. So why even have this debate? Why are we debating Frye versus Daubert? Well, because
Before you get into that,
Yes, sir.
You presented it as an either-or, but there's a third option, that these are actuarial tests, that they're not scientific tests, that they aren't subject to either.
Yeah.
Would you agree that that is an option, or at least an argument?
I will always agree that I may not be correct, that there may be more than what I'm laying out for you. So that is an option. In fact, if you look at it, you break it down, some states, well, Daubert is the law in federal court. That's established. But some states use Frye. Kansas uses Frye. Other states use Daubert, and the remaining third use some other kind of hybrid standard, or they may hold that it doesn't apply.
Daubert is the rule in federal court for science, generally, scientific testimony generally, but is it the rule for these particular two tests?
Well, that's a good question. The federal courts haven't, because this is a state question and not a federal question, the federal courts have not ruled on this particular issue. Nor
Have they ruled on actuarial studies or reports generally?
I think that they have used, well, the main area that they use is tort reform. I mean, Daubert was concerned with government, with using scientific evidence, mainly in tort cases. And there is an article that I reviewed that says that the main use for Daubert in federal court has been on tort cases. And you've got scientific evidence. I don't know as they've gone much into actuarial evidence. I would probably need to brief that or do research on it, but at least in state courts, it's mixed.
Before you proceed to a slightly new issue, counsel, I want to go back. I understood you to say that the Court of Appeals simply said that Frye applied, and I read their opinion to be twofold.
Okay.
And one of them is, as Justice Johnson was suggesting, neither test applies.
That could be correct. Again, you probably have more experience reading this than I do. I think it wasn't clear to me. It seemed positive. They did hold. I know they held that Fry they still retain the standard. They're not adopting Daubert, but I think there was some language in there that indicated that, well, it can be admitted independently of Fry.
If I may, let me read you the language
Okay.
from the opinion. This is page 4, their slip opinion.
Right.
We have it there.
Yes, I do.
Several courts have rejected the Fry admissibility requirements for actuarial risk assessment instruments that are admissible in evidence as a sexual predator commitment proceeding when such tools are simply used in the formation of the basis for a testifying expert's opinion concerning the future dangerousness of a sex offender.
Mm-hmm. Yeah.
And it says, we agree with those courts.
Yeah.
So,
Well,
are you prepared today to argue or respond to our questions about whether neither Fry nor Daubert apply?
Well, yes and no. I mean, I think that you have to have some standard for admissibility in these tests. There has to be some way to judge the accuracy. I mean, the question is, the Fry standard deals with novel scientific techniques. Well, this isn't, actuarial science isn't exactly novel, but the uses we're putting it to here are. These have only been around for the last 10 or 15 years since sexual predator laws came into existence in the early and mid-1990s. If you look at it, the basis of these tests, if you look at the literature, they use a lot of variables. They use regression analysis. They use other things that I don't really claim to understand, and I don't think I could enlighten you on them. But it is more than just, requires a degree of expertise to formulate these tests, and then to determine how much weight to be given to each variable. So we're not just pulling things out of the air. There are, again, statistical analysis of, for example, the static 99. You compare, you're not using an individual's likelihood to reoffend. You're comparing him to a group, and then by some kind of by analysis, you're saying, well, what is the likelihood percentage-wise that people in this group will reoffend? So I think it claims to be scientific. I don't think that I've ever heard anyone say that these are not scientific. I think they do claim that they're scientific. So therefore, I think you have to have some kind of standard by which to judge them. And Fry and Daubert are really right now the two standards that we have available to us. I don't know how I don't agree that you should admit them independently of Fry or Daubert. Or if you do, then I think there has to be some kind of pre-trial hearing to determine the reliability of this evidence. You can look at 60-457, which says that the judge may require that a witness, before testifying in terms of opinion or inference, be first examined concerning the data upon which the opinion or inference is founded. I guess if you reject Fry and you say, well, Daubert doesn't apply, I think 457 would permit a court to say, all right, upon a petitioner to say, we don't believe these tests are accurate. We want an inquiry as to how reliable they are, whether they should be admitted. I mean, this is not a question of, this is a question of relevance, not just the weight. I believe that the Daubert is the proper standard to use, for several reasons. With a Fry test, of course, you have to have several things. You've got to have a person who is an expert in the field testifying. The testimony is based on scientific principles that are generally accepted in the particular field. The expert testimony is beyond the knowledge of the jury, and it's relevant to the facts of the case. What this does is, basically, this is nothing more than counting hands, saying how many experts out there agree that this technique is reliable, and if you get 50% plus one, then it can be said to be generally accepted. So the power to admit evidence in Fry lies with the scientific community. Under Daubert, though, the judge acts as a gatekeeper. The judge has to evaluate the evidence, proffered evidence, on several criteria. Has it been empirically tested? Is it falsifiable? Has it been subjected to peer review and publication? This lets you detect any flaws in the methodology. What's the known or potential error rate? What are the expert's qualifications? Can the technique and its results be explained with sufficient clarity? And there are some other indications in a case, in re Paoli rail yard litigation, 35 F 3rd 717. The Third Circuit attempted to add a few other factors, that the relationship of the technique to the methods which have been established to be reliable, the qualifications of the expert, and the non-judicial uses to which it's been put. I think both Fry and Daubert tried to do the same thing. They tried to let in evidence that's reliable. They tried to exclude junk science. The problem, though, is that Fry is not all that clear about when something goes from being experimental into being reliable. Daubert is. Daubert forces a court to go behind the science, to go behind the opinions, to go behind the test, to see how they were developed, how reliable are they, what are some problems with these tests. I think it's proper that we have the decision-making power over this evidence in the hands of the judiciary, not in the hands of a body of undefined experts who cannot be called to testify, who are not in court. And the standard is, the Daubert standard, I think, is more exacting. It is more capable of excluding junk science than Fry is. You have some things will clearly pass the Daubert test, like DNA testing and intoxilizer machines, but others might not be open to more examination. And I think that the important thing to remember here is what you're talking about with the sexual predator commitment is you're talking about a lifetime commitment.
Mr. Kepfield?
Sir, ma'am.
What's your position on how the evidence in these two cases stacks up under each standard?
You mean the findings?
Yeah. Is it your position that in both of these cases that Fry can be met but Daubert can't?
Well, the judge ruled that Fry test could be met, and
I'm
I think
asking you whether you're contesting that on appeal.
I don't believe that the Fry test can be met. I've read enough and examined enough to know that it is not universally accepted. General acceptance is, again, a very vague term. It can be described as 50% plus one, but I think that the court in Fry deliberately left that vague, and it's remained that way for 90 years. My contention is that I don't believe these tests meet the Fry standard. They certainly don't meet the Daubert standard, and any intensive examination of them would probably yield interesting conclusions on the basis for these tests, how they're conducted, how reliable they are. So my position is that they don't meet either test.
Okay, thank you.
Yes. But again, what we're talking about is a lifetime commitment to the sexual predator unit. I mean, we have now, I think, over 200 individuals at the predator unit at Larned State Hospital. At my last count, only 3 or 4 had been released. It is a serious deprivation of liberty. Now, these tests may be useful for treatment recommendations. They may be useful in showing what sort of forms of treatment an individual needs, but I think they run into serious problems when deciding whether to basically put someone away for life and throw away the key. So our argument is that the Daubert standard is the better standard, that it should apply, that these tests do not meet the standard under either Fry or Daubert, and that Daubert does provides a clear, concise, well laid out means by which a court in the state of Kansas can judge this sort of evidence. If there are no other questions, I will yield my time to Mr. Hillslager.
Have any further questions of counsel? I see none. Thank you.
Thank you, Judge.
May it please the court, Chris Hillslager appearing on behalf of the state. And as the court has already noted, the court need not decide whether the state should reject Fry and adopt Daubert at this time, because in this case the actuarial risk assessment tests and the tables that are derived from that are not scientific evidence. They're simply actuarial tables that are similar to those used by insurance companies to determine risks and life expectancies and so on.
Well, but they're used for more than that. They're used as predictors.
They are.
That's like saying the lie detector test is just measuring who told the lie and who didn't. I mean, these are used to predict whether this individual is going to reoffend.
There's a difference. Lie detector uses scientific principles and analyzes body functions and so on. These actuarial tests just simply look at historical data and categories of actions and persons. They are based on mathematics and statistical analysis.
But they predict, they ask questions, and people that gave these answers reoffended. It wasn't just look at who reoffended, it's people that gave a particular answer. The same as on the lie detector, people whose blood pressure went up. I mean, you have to have a standard. The science comes in when you have an answer to a particular question that carries a meaning.
Well, again, I would submit that is simply a historical and statistical analysis rather than true scientific methodology. And they don't.
I think what Justice Johnson is trying to say, that the calculations themselves don't have any significance unless you give them meaning as far as recidivism, and isn't there a science to giving those calculations meaning?
Yes, but that's where the clinician comes in. The tests themselves are simply tools that they use. They do not in themselves result in any kind of conclusion about this particular individual's rate of recidivism and so on, or whether he's a sexually violent predator. The clinician takes the results of these tests, as well as the clinical interviews and the previous reports, the prior conduct, and so on, and takes all of that into consideration to make the determination as to whether this person actually suffers from a mental disease and can't control themselves and is a sexually violent predator.
But isn't likelihood of reoffending a big component of that determination? And that's where this information is gathered from. I mean,
intuitively, I'd have to say yes, but I'm not one of these clinicians, one of these psychiatrists. I mean, I don't know how big of a factor it is in their overall determination. Intuitively, I'd have to say, yeah, it's probably a fairly significant piece of it, but it's not the only piece, and it's just a tool, and it is based on mathematics, history, statistical analysis, not any kind of novel scientific procedure. And most of the courts around the country that have looked at these actuarial risk tables have determined that they're not scientific, that they don't need to be tested under Fry or Daubert. A small majority of courts have gone the other way, and I'm not saying that that's an unreasonable way to go. I mean, I think reasonable people can disagree on it, but I would say that the majority of courts have said that these aren't novel scientific procedures, that it is just an actuarial table. It's a statistical analysis based on history.
But where you get the science, in my view, is that answering this question a certain way and then reoffending, that there's a correlation. And, you can't just have post hoc ergo propter hoc, that after they took this test, this happened. There has to be they ate breakfast and then they reoffended. Therefore, this person ate breakfast, so they have a 30% chance. You have to have a correlation between the question and the reoffending, and say that there's some cause and effect.
Yes, I'd agree with that.
Isn't there some science in determining which questions, the answers to which questions have an effect or relate to the reoffending? Am I making any sense to you?
Yeah, you are, and perhaps, I mean, again, I'm neither a scientist nor a statistician. My understanding of that correlation goes to the statistical analysis, but of course, the questions that are asked have to come from the psychological field, I think. I've never actually seen one of these tests, so I don't even know what the questions are. And like I said, I don't think it is an unreasonable position to take that these are science. The Court of Appeals below was split. The majority went with the majority of courts that said these aren't scientific procedures. These are just statistical procedures, and they don't have to fall under the Fry test. Judge Malone disagreed, and I think Judge Malone is one of the most well-reasoned judges on the Court of Appeals, so in his concurrence, I think it's persuasive, and I don't think it's unreasonable. Ultimately, these things still pass the Frye test, and my opposing counsel has given the Court no reason to abandon Frye at this point and apply Daubert. Daubert, as I understand it, was adopted in the federal courts as a result of changes in the federal rules of evidence. We don't have the same analogous rules of evidence. Our rules of evidence have been the same for years, and Frye has been held to apply to them, and our rules are statutory, and it was really up to the legislature to make any statutory changes if they wanted to. If they don't like the way that we're analyzing scientific evidence, I think it's up to the legislature to change the rules of evidence rather than the court.
Counsel, before you go on to what might be your next point, I'd like to go back to a point you made at the outset, and that is that some courts have said these particular tests are like actuarial tables used for life insurance purposes.
Yes, Your Honor.
And I think a number of courts have said that. I know you're not a life insurance agent and you're not a clinician, but I would ask, can you tell me what the similarities and dissimilarities are between those two types of tables?
Well, I hesitate to read. I have a quote from the Illinois Court of Appeals. It says, the actuarial instruments merely help the professional draw inferences from historical data or the collective experience of other professionals who have assessed sex offenders for risks of reoffending. In this regard, the instruments are akin to actuarial tables for life expectancy admitted as evidence to a jury for the determination of the gross amount awarded for future pain and suffering, or used by an economic expert to determine the present cash value of a pension. Such instruments simply do not constitute a special scientific principle, method, or test to which Frye applies. That was in re detention of Erba, Illinois Court of Appeals, 4th District. It's cited in the brief.
It's in your brief.
Another one is State Exwell Romley v. Fields coming out of Arizona. The simple quote I pulled out of that is, we conclude that the use of actuarial models by mental health experts to help predict a person's likelihood of recidivism is not the kind of novel scientific evidence or process to which Frye applies. And I know that within the brief I believe I cited others.
That's fine. I'm just curious whether in your research on this subject you've been able to glean what the differences or similarities would be.
Well,
these seem kind of conclusory from the courts.
Indeed, and on either side, I think they're rather conclusory. Some courts, I believe it's the Florida court, went the other way, but they just kind of said, we just disagree. We think that these are kind of scientific, and they went into a whole discussion of, well, what's the literature on it, and is it generally accepted? And they found that it was accepted under the Frye test. I don't know of any court that has rejected the use of these tests either under general rules of evidence or under Frye or Daubert. As far as I know, they've always been accepted by the courts. I came across no decisions that have said that these tests are not admissible under either standard. And really, I think at this point I have covered everything I intended to cover. I would stand on the Court of Appeals majority ruling that these are not scientific. This is not scientific evidence that is subject to Frye. But then, even if the court disagrees and agrees with the concurrence of Judge Malone, that under Frye these tests meet the standard and are admissible.
Do we have any questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Well, the question is whether these are scientific tests. I guess I may be a little simplistic, but I can't do this stuff. I don't know how to do it. Chris doesn't know how to do it. Probably neither of you, unless you have a degree in accounting or actuarial science, know how to do these tests. They are scientific. Again, they are based upon, if you read the literature, there are all kinds of equations and regression analysis in there that when I read it, my eyes went blank. I cannot do this stuff. Probably even.
Well, is that the test of whether you can do it or Mr. Ailsager can do it?
Well, no, but it does. If you look at Fry, though, it says that the knowledge has to be beyond the ken or the knowledge of the jury. Okay, clearly, you pick your average juror; they're most likely not going to be able to do this.
There's a lot of economic testimony that's admitted, a lot of things that get admitted that may be out of the experience of the ordinary citizen, but that doesn't make it science that's subject to Fry. It's up to counsel or to who's ever presenting the evidence to explain it.
Well, that's correct, but I believe it is scientific. The tests, I actually have copies of the Minsost and the Static 99, and basically they asked, Minsost asked 12 questions, static questions, and 4 dynamic questions, and the Static 99 asks about 10 static questions. But again, you're correct that it does. The numbers by themselves are meaningless. The responses by themselves are meaningless. You have to know how to interpret them. And if you take a step back, how do you arrive at knowing that the likelihood, pattern of substantial drug or alcohol abuse prior to incident offense or revocation is scored in the Minsost. The length of sexual offending history, offended against a 13 to 15-year-old victim, and the offender was more than 5 years older than the victim. I mean, why are these significant? Why are they asking 13 to 15? Why not 12 to 14? Why these? There has to be a reason, and again, I believe that this is calling for specialized knowledge. You are basing this upon scientific principles. They may be, not like a DNA test, which relies on fairly hard science. This may be more social science and therefore a little softer. But again, you are deriving these questions from scientific principles that have been established themselves through peer review and being tested multiple times. So clearly it is science. And Kansas currently uses the Fry standard. I agree. Judge Malone says the Fry standard should apply, that this is science, but I'm stating that the Fry test is outdated. The Daubert test is a far more detailed and far more accurate way to gauge whether these tests have any value, to gauge their value for what, again, is a lifetime commitment to a treatment program that may or may not be effective.
But, Mr. Klepfeld, as counsel pointed out, Daubert tracks Federal Rule 702.
Right.
And our legislature has not adopted that. So what is your response to that?
Well, again, I think 6457 allows a way into that. It's not equivalent to Rule 702, but it does say that you can conduct an inquiry upon the basis of this knowledge. I don't know the exact language, but it does seem to me that would permit, if construed liberally, as I think the rules of evidence should be, construed liberally, it would permit a pretrial inquiry, separate inquiry, into the reliability of these actuarial tests. Does that come close to answering your question? Are there any other questions?
Any further questions of counsel? I see none. Thank you, counsel.
Thank you very much.
Thank you both for your arguments this morning. The court will take this matter under advisement. We'll now turn to the next case on this morning's docket. That is case number 1.